Hello, and welcome to this Title IX training video. During this training, I'm going to explain your rights and responsibilities when you experience sexual harassment is reported to you, or allegations of sexual harassment are brought against you. Training on sexual harassment under Title IX is a requirement for all individuals who are employed by a district or charter school or involved in any school program or activity. Please spend the next few moments with me as I outline your rights and responsibilities under Title IX. Title IX of the Education Amendments Act of 1972 states that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. Title IX covers many topics in education, including financial assistance, student housing, employment practices, admissions, counseling, access to courses and programs, pregnant and parenting students, athletics, student rules and policies, such as discipline, sexual harassment, and sexual violence. Today we're going to cover sexual harassment and sexual violence as it pertains to Title IX. New Title IX regulations were released in May 2020. Prior to the new regulations, sexual harassment as a form of sex discrimination was never addressed. The new regulations are intended to clarify sexual harassment as a form of sex discrimination, tighten up district and charter school policies and investigation procedures, hold schools accountable for ensuring a more consistent and equitable response to sexual misconduct allegations, ensure fairness in due process proceedings between both parties, require an educational institution to offer survivors supportive measures, and to ensure educational access for both parties. Now I'm going to cover some definitions that are outlined under the Title IX regulations. Sexual harassment means conduct on the basis of sex that satisfies one or more of the following: a school employee conditioning education benefits on participation in unwelcome sexual conduct, unwelcome conduct that a reasonable person would determine is so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the school's education program or activity, or sexual assault, dating violence, domestic violence, or stalking. Sexual assault is an offense that meets the definition of rape, fondling, incest, or statutory rape as used in the FBI's Uniform Crime Reporting System. A sex offense is any sexual act directed against another person without the consent of the victim, including instances where the victim is incapable of giving consent. Dating violence is violence committed by a person who is or has been in a social relationship of a romantic or intimate nature with the victim. The existence of such a relationship shall be determined based on the reporting party's statement, with consideration of the length of the relationship, the type of relationship, and the frequency of interaction between the persons involved in the relationship.
Domestic violence is a felony or misdemeanor crime of violence committed by a current or former spouse or intimate partner of the victim, by a person with whom the victim shares a child in common, by a person who is cohabitating with or has cohabitated with the victim as a spouse or intimate partner, by a person similarly situated to a spouse of the victim under the domestic or family violence laws of the jurisdiction of which the crime of violence occurred, or by any other person against an adult or youth victim who is protected from that person's acts under the domestic or family violence laws of the jurisdiction in which the crime of violence occurred.
Stalking involves a person engaging in a course of conduct directed at a specific person that would cause a reasonable person to fear for the person's safety or the safety of others, or suffer substantial emotional distress. Course of conduct under this definition involves two or more acts, including, but not limited to, acts in which the stalker directly, indirectly, or through third parties, by any action, method, device, or means, follows, monitors, observes, surveils, threatens, or communicates to or about a person or interferes with a person's property. Substantial emotional distress means significant mental suffering or anguish that may, but does not necessarily require medical or other professional treatment or counseling. And reasonable person means a reasonable person under similar circumstances and with similar identities to the victim. Now we are going to discuss the grievance process when you experience any of the described actions or allegations, or these actions are reported to you. The overarching principles of the grievance process involves written grievance procedures for dealing with sexual harassment that must abide by the Title IX regulations, and a requirement that the grievance process cannot itself discriminate against a complainant or respondent on the basis of sex or status. Therefore, the response to allegations of sexual misconduct must apply equally to both parties, and the remedies for a complainant must be designed to restore or preserve equal access to an educational program or activity. Under Title IX, the two parties are referred to as the complainant and respondent. So, what activates a Title IX investigation? Once an employee has actual knowledge of sexual harassment or allegations of sexual harassment, this places the educational institution on notice and activates the recipient's legal obligation to respond promptly. Actual knowledge means notice or allegations received by the Title IX coordinator, school official with the authority to institute corrective measures on behalf of the school, or any school employee. When an allegation is reported, it is not up to the individual who has the actual knowledge to determine if the allegations are true and qualify as sexual harassment as defined under the law. Their only obligation is to report the allegations promptly to the Title IX coordinator or another school official. Here are a few things to note when an allegation is reported. Regardless if a formal complaint is filed, the person who alleges sexual harassment should be treated as a complainant until further action is taken, and supportive measures should be put into place immediately. In addition, both parties, the complainant and respondent, should be treated equitably. It is important to note that if you or someone else files a formal complaint and decides to retract it, the district or charter school Title IX coordinator can make the decision to continue a formal investigation. So what do I mean when I say supportive measures need to be put into place? Some examples are no contact orders, academic accommodations, health and mental health services, and disability services. There are a range of considerations when determining the supportive measures that will be put into place. They must be non-disciplinary, non-punitive, and individualized. Also, they should not be unreasonably burdensome, protect the safety of both parties and the educational environment, and deter harassment. Remember that the respondent must be presumed innocent until determined otherwise through a formal investigation, and supportive measures should be equitable for both parties. I know this is much easier said than done, but you just need to do the best you can, and you won't be able to satisfy the wishes of both parties 100% of the time. Each charter school or district determines their policies and grievance procedures, which should be widely disseminated by the district or charter school and meet the policy requirements of the Title IX regulations. It is important for everyone to know how to file a complaint and the process involved once a complaint has been filed. One of the changes under the new regulations is that there must be a process or mechanism in place where anyone can file a complaint during business and non-business hours. There's also no time limit or statute of limitations on a complainant's decision to file a formal complaint. There are some grounds for mandatory dismissal when a formal complaint is filed. A district or charter school must dismiss a formal complaint that does not describe conduct that meets the definition of sexual harassment, that is severe, pervasive, and objectively offensive. This will be determined by the district or charter school Title IX coordinator, and a complaint must be dismissed if the complaint alleges sexual harassment that did not occur in the school's education program or activity, or did not occur in the United States. Keep in mind that complaints that are dismissed under Title IX can still be addressed under the district, charter school, and an individual school's code of conduct. There are grounds for the emergency removal of a person who is alleged of sexual misconduct. A respondent can be removed from educational programs or activities on an emergency basis if the respondent poses an immediate threat to anyone's physical health or safety. The district or charter school should perform a risk analysis, provide the responding party with notice and an opportunity to challenge the decision immediately following the removal, adhere to their own policies on what qualifies as an immediate threat, and they must comply with discipline regulations under the Individuals with Disabilities Education Act, Section 504 of the Rehabilitation Act, and the Americans with Disabilities Act. It is important to note that retaliation is not permitted under the law. The United States Code of Federal Regulations states that no recipient or other person shall intimidate, threaten, coerce, or discriminate against any individual for the purpose of interfering with any right or privilege, or because he has made a complaint, testified, assisted, or participated in any manner in an investigation, proceeding, or hearing. There are specific procedural responsibilities for district, charter school, and school officials. They must promptly contact the district or charter school Title IX coordinator when sexual harassment is reported. Each district or charter school is required by law to assign a Title IX coordinator. They must keep detailed records, ensure that training on sexual harassment is provided, and assist in determining supportive measures and expediently put supporting measures into place. As a reminder, regardless if a formal complaint is filed, the person who alleges sexual harassment should be treated as a complainant until further action is taken, and both parties should be treated equitably. In regards to record keeping, records must be kept for 7 years and should include records of a school's investigation, any appeals and materials associated with an appeal, records of any informal resolution process, all materials used to train employees, and the supportive measures that were put into place. Let's review what your responsibilities are when sexual harassment is reported to you. You should inform complainants who they can go to for reporting incidents of sexual harassment. You must immediately report the allegations. If necessary, assist in offering supportive measures. These will be determined by a district, school, or charter school official, and maintain confidentiality and adhere to the Family Educational Rights to Privacy Act regulations. It is also essential that you know what the grievance procedures are in your district or charter school and how to file a complaint. This is for your benefit and the benefit of others. Remember, these rights and protections apply to you as well if you experience sexual harassment or charges of sexual misconduct are brought against you. Following this training, I have some assignments for you. Please find out who your district or charter school Title IX coordinator is. Request the Title IX policies and know the grievance process for filing a complaint. In addition to filing a sexual harassment complaint to your district or charter school, you always have the right to file with the Office for Civil Rights. I have provided you with the contact information for the Region 8 office in Colorado. One last thing, I am not an attorney. I am not offering legal advice. The information provided for you in this training is an overview of your rights and responsibilities under Title IX and the regulations that you need to know concerning sex discrimination, sexual harassment, sexual assault, sexual violence, and dating violence. If you have specific concerns related to the law, you should consult with your district or charter school administrator, Title IX coordinator, contact the Office for Civil Rights, or seek legal counsel. Thank you for joining me in this Title IX training. I hope you have a better understanding of your rights and responsibilities when you experience sexual harassment is reported to you, or allegations of sexual harassment are brought against you. It is important that we all do our part in preventing and addressing sexual harassment and sexual violence in all of our educational institutions.